What's up, YouTube? What's up, YouTube? Bong hits for Jesus. What you know about this one, baby? Oh, man. You know, I'm always telling you about my case briefs. I wrote this one a couple of weeks ago. Yeah. Well, thank you for tuning in. Now it ends the future. Well, we have homegrown content over here. You know, none of that jive about sponsors and advertisers and GoFundMes and Cash Apps and Zellies and all of that. I don't need your money, honey. I got my own. I'm good. Trust and believe I'm good. But I'm not knocking anyone's hustle. You know what I mean? Because, hey, I may do that in the future in some of these other channels. Just not on this one. Here we go. All right. I'm about to light up a joint because it's only fitting that I do that. Considering. Oh man, this thing is good. I'm telling you, this is that good stuff. Ha! So good and make you. Oh, I'm stuttering. So good and make you want to slap your mom.
That's the plot thickens. It gets me ridiculous, reminiscent of
All right, let me stop being goofy. All right, so it's only fitting I play smoking songs. You know, Spotty, Oddie, Dope-alicious. Yeah, I went way back. I'm gonna take one more puff. Ooh, yes. Ooh. All right, so the famous Bong hits for Jesus case. I've been wanting to put this out there and talk about it a little bit. So today is going to be that day. Now, like I said, I don't know anything about the law, so don't ask me anything. You know, don't get it twisted. I don't know nothing about nothing, okay? I don't know too much. Anyway, here we go. Case brief, Morse versus Frederick. Citation, Morse v. Frederick, 55 U.S. Courts. Of course, we had to do that little thing down there to properly MLA citation format. 127 SCT 2618 2007. So, facts. In 2002, an 18-year-old high school student by the name of Joseph Frederick decided to test the limits of free speech by enlisting several other students in publicly displaying a 14-foot banner with the phrase, "Bong hits for Jesus," at the 2002 Winter Olympic Games torch relay passed through the town. Okay. Although Frederick claimed that it was just a nonsense stunt, and keep that in mind, he himself said it was a nonsense stunt, the school did not see things the same way. The principal of the school quickly took the banner from Frederick, and he was subsequently suspended for 10 days. Now, actually, it was 5 days at first, but he had mentioned a quote, I think it was by Samuel Adams or something, about the law, and she got pissed over it, so she gave him an extra 5 days, so it ended up being 10 days. All right, the school argued that the student had violated school policy and through this behavior was encouraging the use of illegal drugs. Joseph Frederick had already had a previous history of conducting various free speech experiments at Juneau Douglas High School. In one of those previous experiments, Frederick refused to stand up and recite the Pledge of Allegiance. When he was held to task, he proudly reclaimed the Barnett decision, and that's a Supreme Court decision, Barnett decision citing that the public school students have the right to opt out of participating in the Pledge of Allegiance. So this is a young lawyer. I think he was I don't know if he ever became a lawyer or not, but I think he was interested in law. And like many teenagers, he felt that, he should challenge these things. And I think that was it was harmless, right? He's not challenging authority in harmful ways. He's challenging authority in search of what the perimeters of the law, what the perimeters of the different laws are. And first of all, and more importantly, Bill of Rights and the amendments. So here we go. He won that experiment and continued to conduct further free speech experiments. So he was interested in free speech, and he was doing some experiential learning, right? So here we go. Let's go a little further. His action technically occurred off school campus, and he was considered an adult at 18. So he was 18, and this action didn't happen on the school campus. And so that was part of his argument, was that, well, since this wasn't on school grounds, that, come on, baby, come on, baby, come on, baby, come on, come, yes, good cat. All right. I had to let my little devil out because he will jump right into this keyboard and shut this whole thing down. Anyway, where was I? All right, so he had already had a history of challenging authority, and like I said, that's normal for teenagers and high school kids to go out there and challenge authority. I mean, even adults challenge authority, and there's nothing wrong with challenging authority. I'm all for it. I'm all for challenging even things that are not authoritative. Be skeptical, question things, and check it out, verify, so forth. All right, anyway, his action technically, wait a minute, yes, his action technically occurred off school campus, and he was considered an adult at 18. There were 2 points that worked to his favor in regards to the argument of whether his First Amendment rights were protected or not. However, 5 members of the justices saw things differently. They felt that although he was not directly on the campus, he was at a school-sanctioned activity that held teachers and school administrators legally accountable for the students, including Frederick. The court rejected Frederick's contention that his First Amendment rights weren't protected and ruled that schools may take steps to safeguard, quote, schools may take steps to safeguard those entrusted to their care from speech that can reasonably be regarded as illegal. The issue, let's go on to the issue. Does a policy prohibiting a student's expression of speech by publicly displaying a banner that says "Bong hits for Jesus" during a school-sanctioned outing violate the student's First Amendment rights to free speech? What do you think? Before we go any further, what do you think about that? What is your holding on that? Do you think it does violate the First Amendment rights of that student? Or do you agree with the judges? Now, I want to tell you this. I'm a mega pro cannabis person, pro psychedelics. I'm pro all psychedelic, well, all the natural psychedelics. I'm not pro I'm not pro meth or crack or, those, there's good drugs and there's bad drugs. And 9 times out of 10, bad drugs are made in the lab, and that includes the ones that's legal too, okay? So the good drugs usually come up from out of the ground. Okay, and you don't have to do anything. You don't have to cook them. You don't have to add anything. Now, some of them you can boil into a tea, but you don't have to. You can just eat that stuff straight out of the ground, okay? Anyway, cannabis, I'm a big pro cannabis person. I don't think it's an illegal drug. I don't think it should be an illegal drug. I know it's illegal in some areas, right? But it should not be, because it is less dangerous than alcohol, cigarettes, and aspirin. So, the world still has to catch up with the cannabis thing. I know there's a lot of countries that are that have either legalized it or decriminalized it or on their way to do that. And then even further, there's some that's even legalizing psychedelics like magic mushrooms and DMT and all of that. So we'll see as the world progresses. But what is your holding on that? Do you agree with the judge's decision or do you disagree? Okay, well, let's see what I have to say. Holding, no. A policy prohibiting a student's expression of speech by publicly displaying a banner that says Bong hits for Jesus during a school-sanctioned outing does not violate their First Amendment rights to free speech. And here's the question. What does free speech mean? Are we allowed to just say and do anything? When I say do, free speech, it also includes acts of symbolic expression, like burning the flag, right? There are laws against burning the flag or burning a sacred governmental symbol, right? Or destroying a sacred governmental ornament, right? You can get in trouble for that, and the flag files under that. But then there are instances where there were Supreme Court rulings in favor of individuals who burned the flag. So what does free speech actually mean? What does it really mean? Can we just say anything? Is our free speech violated when we are prohibited from saying certain things? When we are censored? Let's see what this says, what we've got here. The rationale. The U.S. Supreme Court reached a 5-4 decision and ruled that the First Amendment does not prevent public school officials from prohibiting student expressions that could be reasonably viewed as advocating the use of illegal substances. Now remember, I don't think cannabis should be illegal. The majority of the justices cited Bethel v. Frazier, 1986, in which the court ruled that the students do not have any First Amendment rights to produce obscene or lewd speeches at school. And in that case, the guy was a high school kid, and he made a speech for one of his buddies to vote him into the student body, president of the student body or something like that. And he had, the speech was metaphorical, but it definitely had a strong sexual component to it. And, they didn't like that. So that went all the way to Supreme Court because I think he was also suspended and he was also prevented from speaking at the graduation because he was, I think it was an honor student. He was going to speak at the graduation commencement ceremony and all of that. And they did not let him do that after he did that. So, so that he took it all the way to the Supreme Court, and the court ruled in Bethel v. Frazier that students do not have any First Amendment rights to produce obscene or lewd speeches at school, and they considered what he did lewd and obscene. I might do a video on that case brief. It all depends. I've got a couple of case briefs I want to do a video on, but I really like this Bong Hits for Jesus. I just knew I was going to do a video for that because that's just classic, right? All right, here we go. In addition, they also cited Hazelwood v. Kuhlmeier, 1988, in which the Supreme Court ruled that school administrators do have the right to prohibit student speech in school-sponsored newspapers. Now, in this particular case, the students, they weren't just goofy and silly. They weren't trying to necessarily challenge authority or anything like that. They were including stories of students, real students there, that were experiencing teen pregnancy. And they, the administrators they weren't having it. They were not having it. This was back in 1988. I mean, teen pregnancy was really rampant in the school I was in. I knew some girls that were like 14 that were pregnant already, 13 and 14, It's really sad, but teen pregnancy was not anything unusual. It was, it was not something that I had never seen or heard of before. So, but, I wasn't in high school in 1988 either. So I don't know, maybe they were still different. The the societal ways of thinking about that. But in any case, those school administrators took that story out before it was published, and so these high school kids were upset when they saw that their stories were not in there about the pregnant teen. And they had interviewed the pregnant teen, and they had changed her name, kept it anonymous, so they weren't putting people's names out or anything, but everybody in the school would know who that is, right? So there was also this thought that the administrators did not want to risk putting someone out like that, putting their business out, and maybe having it come back on them, even if the kid consented, because it's a kid, and they could get into legal trouble if the parents decide, hey, why did you guys do this to my kid, right? So I totally understand that part. Also, that school newspaper was sponsored by the administration. So it was their money, right? So I get that too. Hey, do it on your dime, not on mine, right? And that's what the kids ended up doing, the high school kids. They ended up printing those stories and passing them out in the school, and that was acceptable. They were allowed to do that. So it was just they didn't want to do it on the school-sponsored newspapers. And I totally agree with that. Okay, all right, so let's go on here. Now, that was Hazelwood v. Kuhlmeier. And, again, I might make a video on that, but we'll see on that. All right. Anyway, the Supreme Court justices felt that Frederick had expressed his speech at a school-sanctioned activity. Chief Justice Roberts created a new rule in the student speech world in that school officials can restrict student speech that they reasonably believe advocates the use of illegal drugs. Okay? In Morse versus Frederick, the court acknowledged that the Constitution affords lesser protections to certain types of student speech at school and at school-supervised events. This is significant because Frederick contended that since he was not actually on the school grounds, that his free speech had been violated when the principal took the banner from the students and suspended Frederick. By his very own admission, Frederick stated that his message was not a political one, but was just, quote unquote, a nonsense stunt. And this, folks, here is the crucial key for me. Excuse me. He himself said this was just nonsense. There was really no purpose behind it, right? It was just being goofy and goofing off and being a butt. Therefore, this was not quite like the Tinker case, and the court concluded that the phrase "Bong hits for Jesus" could reasonably be viewed as encouraging illegal substance abuse. Due to this, the state had a compelling interest in restricting and punishing this type of speech. The court ruled that schools are within their rights to take the proper steps to safeguard any speech that can be seen as promoting the use of illegal drugs, without it being a violation of the student's First Amendment rights. Now, let's look at the significance here. This case is significant because a new rule was made about the student speech and the ability of public school administrators to restrict and prohibit any student speech that they reasonably believe to promote the use of illegal drugs. Now, like I said, I'm mega pro cannabis. I'm mega pro psychedelics, magic mushrooms, DMT, mescaline cactus, you know what I mean? But now I totally get this because at the time, this was illegal, right? I don't know if it still is over there in that state, but I'm all about, stay in school, fool, and focus on the books, all right? You don't need to be smoking cannabis. You don't need to be drinking alcohol. You don't need to smoke cigarettes. You need to drink milk, or drink your orange juice or your water and read your books. You need to stay in the library and drink your milk. And, if you think you want to do some kind of smoking, okay, you need to be smoking on those books, okay? Your eyes and your hands, those pencils and pens need to be smoking on those essays and those book reports. You know what I'm talking about? That's the kind of smoking I'm talking about. Don't smoke the other stuff, okay? Wait until you're 21 and then go to somewhere where it's legal, okay? Save your bus money, your Greyhound bus money, or your plane ticket money, and fly to a state where it's legal when you're 21. Okay? So that's my advice. So here we go. Frederick had already himself admitted that this was not a political expression of speech, but instead called it nonsense. Therefore, his First Amendment rights were not violated. Did this expand rights? Yes, it certainly expanded the rights of school administrators to safeguard the school institution from the type of speech that would promote or encourage illegal drug use activities. I don't think cannabis is a drug. I don't think it should be illegal, as I've said a zillion times before now. But because in the eyes of the law it is classified as such, that terminology I will be using in the case brief, right? That's what I'm using in the case brief. Personal opinion. In reviewing this case, I'm reminded that the familiar connections of terms such as liberty and law, liberty and equality, and liberty and justice breed a type of neglect of meaning that they confer upon each other through our traditional association of them. We use these terms interchangeably, but they are not the same. These liberty and equality and justice and freedom of speech, or freedom, these are not the same things, folks. These are not the same things, especially when you're talking about the law. This may seem like English, but it's not the definition you think it is. So you have to understand the legal definition of these terms, and more importantly, the implication legally as concerns to free speech, First Amendment rights, and the other types of amendment rights that I may talk about in the future. Okay, so here we go. Is it true freedom of speech? Is true freedom of speech the ability to just say and do whatever we want? Is that really true freedom? If you think about what freedom means, the idea, okay, right now, what you think it might mean. Does it mean to do anything? Freedom of speech, does it mean the ability to just say and do anything? I certainly have to chuckle at the phrase "Bong hits for Jesus." While I personally am a huge proponent for the legalization and free access to psychedelics, including cannabis, I also believe that everything has the proper time and place for it. I do not believe cannabis to be a dangerous, quote, drug. However, I do believe in following the laws and rules of one's location, which includes school-sanctioned outings. I also think that schools should have the right to keep order when it comes to the students and the institution of school. Frederick was already performing various free speech experiments at his school and therefore had a history of challenging the authority of school officials. In addition, since his demonstration with the banner was not political and just, quote, nonsense, as he himself called it, there was really no good purpose behind the act other than perhaps to get attention and defy the school authorities. While it is certainly normal for high school students to test their limits with teachers, parents, and other authority figures, this action can definitely be seen as a risk to not only other students, but also the school administrators. Although this did not happen on the school campus, this was a school-sanctioned outing that held teachers and administrators legally responsible for the safety of the students. Therefore, I agree with the court's decision in that the public school officials do have a right to prohibit and restrict the speech that they feel could be seen as promoting illegal substance abuse and therefore a safety risk. A passage from Mortimer Adler's Syntopicon, chapter 47, titled Liberty, comes to mind. It quotes Georg Wilhelm Friedrich Hegel, stating that freedom does not mean freedom from law. but that freedom is nothing but the recognition and adoption of such universal substantial objects as right and law. Having said that, if Frederick, oh, my German's coming out, if Frederick would have taken the same course in protest of prohibitive laws against cannabis, then I would have disagreed with the court's decision, as this would have been a political demonstration that should have been protected under the First Amendment. So that's my opinion, folks. Yes, had he done the very same action as a political demonstration, I would have disagreed with this decision, because then his First Amendment rights would have been violated. But because he was just basically farting into people's faces and thinking it's cute, you know, he was a high school kid. You know, what do you expect? I think he was on the right track when he was trying to test his First Amendment rights, you know, his free speech, and the thing with the flag where, you know, he didn't pledge the allegiance. But then he just got kind of goofy with it. You know, he got stupid with it. And, you know, he's a high school kid. What do you expect, right? But it did go all the way to the Supreme Court. And I'm glad that he took it all the way to the Supreme Court, because this was a landmark case. So some of the works cited here is Mortimer Adler, The Great Ideas, a Syntopicon of Great Books of the Western World, pages 991 through 1000. Fire Starters, Morse versus V. Frederick on YouTube. And then we have Georg Wilhelm Friedrich Hegel, Elements of the Philosophy of Right by Dover Publications. And that is the one that's translated into English. Of course, I read the German version, but I couldn't quote directly from the German version, so I had to go ahead and pick up the English version for the case brief. But it makes for some very good reading. Also, we have the Oxford Guide to the United States Supreme Court Decisions, 2nd edition, by Mark R. Killenback. And, of course, that would be the Morse v. Frederick case that is listed in that one. Then we have the United States Courts, Facts and Case Summary, Morse v. Frederick, United States Courts, 25th of June, 2007. So, that's it, folks. That's the famous Bong hits for Jesus case. What do you think about this one? Do you agree with the decision? Do you think it's right what they had, what they decided, or do you think it's just not the, you know, just not the thing for you? Anyway, I'm going to be seeing ya. Have a good one. Enjoy the rest of your weekend.